and it looks like it is noon. So we're going to start. I want to thank you all for joining us. Alvin Wellington Barlow is my name. I'm from Jacksonville, Florida. Been practicing law since 1985. It's 20 years for me this year. Started out in the public defender's office. I'll talk about that in a few minutes as we get started. And I appreciate you all for joining us today for this very hopefully interesting CLE. Have technical difficulties here. Get my okay. So this CLE is for 1 hour general and criminal appellate law 1 hour and criminal trial law 1 hour as well. It's been approved by the Florida Bar for December 18, 2024 through June 30th, 2026. And I'll tell you how you can get your credit at the end. Instructional outline for today, introduction of the facilitator. We'll talk about arrest and booking report, a charging document, pre-trial motions, very important. Discovery, searching for the truth, the whole truth and nothing but the truth. That was the theme for this particular case. Audio excerpts from trial, testimony and closing. Jury questions, 2 of them came based upon some questioning that I did. Case essence and summation, and one of the things I like to do is kind of bring a case to the essence. What is the true essence of the case? I'll get into that later. Look at the not guilty verdicts, the not guilty judgment, and we'll talk about the equity and sentencing analysis system if we have time. And this is how to handle a case that you lose at trial, because the battle is not over. As a matter of fact, you can win the war after having lost the battle in the trial. I've had cases that I lost when the sentencing was better than what the prosecutor had asked before we went to trial. So that's losing the war. I mean, the battle, excuse me, and winning the war. And then we'll look at expert witness services as well. Then we'll have a brief Q&A, anonymous survey, and I'll talk about how you can get your particulars. As far as the introduction of the facilitator, I started my career as a legal intern in the state attorney office in Jacksonville in the summer of 1985. I graduated from the University of Florida in December of 85. So I was actually practicing law under that certified legal intern program that the Florida Supreme Court had. Hopefully they still have it. So I was actually practicing law a year before I actually got into the bar, which was in September of 1986. And that was my card as a public defender. Once I left the state attorney office and graduated, I started working in the public defender's office. And I always tell people that was the best job I've ever had. The pay was lousy, but the work was excellent. We got to do a lot of great things with meager resources, and having prosecuted and done defense work. I can tell you right now, there's more challenging to win a case that you don't know what's going on. You have to put everything together. It's a lot different than prosecuting a case when everything is brought to you and you just have to line up the ducks and shoot them. Here's my current business card, downtown Jacksonville. Investigating and trying a case is an art and a science. It's an art and a science. It's not just an art. It's not just a science. It's a combination of the twain. And some aspects are cold, objective, and scientifically structured, while others are warm, subjective, and esoterically amorphous. And if you cannot adjust to both ways, you're going to have some difficulty trying cases. Translation sometimes is just gut feelings that will dictate actions that defy all logic, reasoning, and or academic training. I've had unctions to do things that they told us in law school, never, ever, ever do this. And I was moved to do it, and I did it, and we won the case. And I can tell that the case turned when I did what I was taught not to do in law school. Here's the arrest and booking report from this particular case. And my client was a 19-year-old African-American male. He's arrested July 9th, 2010, after he had just graduated from high school. He was accused of sexual battery with a victim by force not likely to cause serious bodily injury. So he's immediately facing 15 years in prison. and he was in dire situations and circumstances because he had two options to go to two full ride scholarship offers to go to college to play football, and he was charged not only with this case but another one. So he was technically facing 30 years in prison, 15 on this one and 15 on the other one. But that for the worst change, and I'll get into that later on. Here are some of the allegations: a consensual, penile, vaginal intercourse. And let me just stop right here for a second. Ladies and gentlemen, we're going to get into some very detailed discussions that are intimate and sexual and all that business. I'm going to try to be as delicate about it as possible, but this was a sexual battery case. So you might hear some language that may be a little offensive to you. Hopefully it won't be. I'm just letting you know to prepare yourself, brace yourself, because I really get into the nuts and bolts of this case, and I had to. So it was consensual, sexual, penile, vaginal intercourse, but she claimed that she changed her mind when he started getting rough. So she initially consented. Then when he started getting rough, allegedly told him to stop. He wouldn't stop. And so the state's burden of proof was to prove the withdrawal of consent beyond and to the exclusion of a reasonable doubt, which I knew they couldn't prove. And that's why I wanted to try this case first, because I knew it was a lot stronger than the other one. They set the other one for trial first, but I then demanded a speedy trial in this one because I wanted to go to trial on this one first, and I'll show you that in a minute. Here's the actual information. In Duval County, state of Florida, sexual battery, slight force, 794.0115. Initial charge filed July 27th. I'm highlighting this date because I'm going to show you something in a few minutes. It was originally, these charges were investigated and then filed July 27, 2010. Sexual battery, slight force. That's force not likely to cause bodily injury. And he was facing up to 15 years on this single charge that they filed. So the first thing I did was I filed a motion to prohibit the state from referring to the accuser as victim. Now, this is before Marcy's Law. And so one of the first things I realized in my discovery was that she was not a victim. And so number two, I did not want the state to go in a 3 or 4 or 5 day trial calling her a victim all that time. And that got psychologically bottled up in the juror's mind. So I thought about filing a motion. I'd never heard of it before. So I filed a motion to prevent them from calling. And I thought it did. And I'm going to show you how that works in a few minutes. But it's to prevent them. Now, this is even in discovery, because I don't even want them calling her a victim in a discovery deposition that's going to be in a transcript that's going to be read back when you're impeaching a witness or whatever. So it's about at depositions, hearing on motions, trial testimony, opening statement, closing argument, or any stage of these proceedings, or until a jury has found the defendant, in fact, guilty, because technically that's when you can say he's guilty. And that's technically when you can say the alleged victim is a victim. And not until a jury comes back or he pleads no contest or guilty can they lawfully call him I'm sorry, lawfully call her a victim. A lot of lawyers don't know that. And so that's the dynamics of the motion and everything. And so what this CLE is about is discovering the truth, the whole truth, and nothing but the truth in discovery, in the discovery process, and then utilizing discovery depositions to lock witnesses in to their testimony so that you can then pin them down and cross-examine them like you want to. Now, let me just say this right here. I had to be very delicate. I had to destroy the credibility of the victim, who was only 19 years old, while at the same time not looking like I was overbearing over her because she was a child and I was an adult. And I had an adult jury, so I had to be very delicate. I could not afford to alienate the jury. But at the same time, I had to let the jury know she was lying, and she was very cleverly lying. So I was firm but fair. That's the best way I can explain it. This case was a perfect storm because I had a lying victim who would say anything. She was jealous of him. She wanted to marry him. He didn't want to marry her. She was just a piece of meat to him. She wanted to be more. I had a very aggressive prosecutor who had been running roughshod over public defenders and private attorneys, getting life sentences on people like it was nothing. before she met me in this case. Then I had a judge who had only been on the bench 18 months, had a private practice before he got elected to the bench. Nothing wrong with being elected, but he had never handled a criminal case, not even a DUI, not even a driving while license suspended. Then he gets elected to the circuit court. And you know what typically happens? These judges tend to rely upon the state more than the defense. And so that's what I had, a judge who was relying on the state attorney. It was so terrible that he was allowing her to use leading questions in her own direct examination. So how do you handle that? Well, I had to explain to the jury that's not the way you ask witnesses questions. So I had to show them how I was asking their witnesses questions and how they were asking their witnesses questions. So I had to deal with that. So this is the deposition that I believe turned this entire case. This is the lead detective, B.W. Thomas. I took his deposition on August 25th, 2010. It turned out a lot better than I ever expected. I was ready for him. I had done a lot of research on him, a lot of research on the case, I knew everything about this case that I could know before I went into these depositions. So I was prepared to question him like I wanted to question him, and I wanted to direct him in a certain area, and it worked even better than I thought it would. So I filed a demand for speedy trial. The first thing I did was got everything. I deposed just about every witness that I could, all the Category A witnesses. So I was ready. So I immediately filed a demand for speedy trial. Okay. Now, usually you don't do that, but I was ready. I had a strong case, and I wanted to try this one before the other one because the other case was weaker than this one. I was pretty sure I could win this one. As a matter of fact, the bailiffs went around telling I asked the judge if I could record this. So the whole trial was recorded audio, and I'll have some audio excerpts for you later. And I got the judge's permission to record the closing argument with a professional videographer. And so the whole closing argument is documented as well. So the bailiffs would go around the courthouse saying Barlow knew he was going to win this case. No, I didn't know I was going to win it. I knew that I had a good chance of winning it. And I know that I do CLE, so I wanted to prepare have some of these things prepared for CLE. So here's one right now that we're doing today. So I filed this demand, let the judge know, he had two cases and we want to try this case. So we filed that demand, and we got a filed amended information within 7 or 8 days after I filed that speedy trial demand. Now, somebody just tell us, why did the state amend the information? Why did they do it? What were they trying to do? Somebody just unmute and tell us right quick. Don't be shy. What was the state trying to do by filing an amended information so late and we're getting ready to go to trial? What was she trying to do? Anybody? Right quick. Just
Trying to
say
stall.
again.
They're trying to stall the case out.
Exactly. She was trying to slow me down. And I wasn't going to have that because I was prepared. I knew she wasn't prepared. So this is one of those strategic situations where I was using her caseload against her. I knew she wasn't ready, but I was ready. I was ready for this case. So I had to fight that. This is unusual. I had to fight a motion. I had to fight this amended information. I told the judge I was ready. We still want to go to trial. So that was filed within 8 days. And she bumped it to sexual battery with force likely to cause serious bodily injury. That bumped it up from 15 years to life, just like that. Now, she knew that there was no allegation in court. I said on the record, Judge, I'm going to file a bar complaint against her because she knows that there are no facts and circumstances surrounding this charge. Yet she's using my client and risking him having a life sentence just for one upsmanship in a trial. So the thing I regret is when I calmed down, I didn't file that bar complaint, but I should have done it. She also charged him with domestic battery by strangulation. He was never even arrested for that, but she made an allegation that he choked her. Now, that allegation was already made when she filed the first information, but she never filed that charge. So that was the other basis I was going to file that bar complaint. So what I had to focus on, I had to change my strategy and adjust to it. And I had to focus on this right here. Because when you're talking about domestic battery, you're talking about in a family, a household member, or a person with whom he or she is in a dating relationship. And so that's what I knew that's what they were trying to use because they weren't related to each other, didn't live with each other, and they wanted to say that they were dating. So I had to destroy any evidence or allegation that they were dating. And as you'll see from the clips, how I was able to do it by the grace of God. So here's a minute information, sexual battery with great force, with along with battery by strangulation. So now he went from 15 years to life plus 5 years. Life plus 5 years. So I explained to the client, he was terrified. I said, listen, you're facing worse time, but she made it easier for us to win the case because there are no allegations of any violence. Well, there were allegations of violence, but there was no evidence of violence. And that's very important. And we're going to look at that. So here's from the clerk's office as for this yesterday. We did a demand for speedy trial on that date. Judge set the case for final pretrial on that date, for jury selection on that date, and had another final pretrial modified. And then they amended that information on that date. But it's not over. Then they filed a motion to strike the defendant's demand for speedy trial. When I didn't slow down and I kept going, they still wanted to slow down and get ready. So they filed a motion to strike. I would venture to say this is the first and only time I've been practicing on 40 years. I've never had a motion to strike a demand for speedy trial. And I filed some demands for speedy trial. So that's how desperate she was to stop this freight train from coming. So I argued it. The judge looked at the record. He made a record saying everything I had done to prepare this case for trial. He articulated on the record and said defense is ready for trial. So he denied the motion, and then we went on to trial. So I pulled some audio excerpts, and I pulled really a lot of them were video, but I reduced it to audio because I know sometimes, depending upon your connectivity, you might not be able to see a video. But it was one video I did leave, and it's her, the prosecutor, trying to recover after I had destroyed her lead detective. So I have that video. Hopefully it'll play. If not, I reduced it to audio, so we have that option as well. So the following excerpts were edited from audio and video files that were recorded during the trial with the judge's permission. The entire trial was recorded. I already said that before. MP3, I had an MP3 recorder, and I was mic'd up and everything. I had a lapel mic on and everything, and recorded the whole trial that way. And so here is the first opportunity that I got to use that motion to prevent the state from referring to the accuser as victim. You might want to turn your volume all the way up because some of these audio files are louder than the other ones, okay? Now, once you file a motion like that, number one. Number two, if it's granted, now you have to be poised and ready to pounce. You have to be listening attentively every time anybody in that courtroom calls that person a victim versus their proper name or alleged victim or accuser. Those are the words that I didn't mind him using. Accuser, alleged victim, or by her proper name. And it just wreaks havoc when you get one of these files and you start enforcing it.
So, the defendant's information to you in his interview directly contradicted your observations about the victim, right?
Objections, alleged victim, Your Honor. Standing order.
When you interviewed the defendant, he was the one to bring up race. When you're talking to someone who purports to be a victim of a crime, a victim of a sex crime, do you treat them the same as you would a victim of a property crime? Mr. Barlow asked you several times about victim statements you hearing on the control call being inconsistent with your
Objection, alleged victim.
I'm literally sitting on my seat, hands on the chair, waiting and lying in wait because I know they're used to saying victim. Nobody's ever really challenged them on that. So I knew I was going to have to do that all day long, every day of that trial. And it worked. It worked so well that it really interrupted any rhythm that they could ever get in terms of questioning their own witnesses. So the Sexual Assault Response Center nurses alleged victims' inconsistencies. What I did was I compared the detective's report with the SART nurse's report, and I was shocked at how many inconsistencies I had because she was lying the whole time. She told the police one version, told the SART nurse another version, so I had to maximize that. So I have a dichotomy of what she said to both. So here it is. He inserted his fingers. He didn't do it. He performed oral sex. He didn't do it. Started getting rough. No, just changed her mind because she was telling the detective, I changed my mind because he was getting rough. Told the SART nurse, excuse me, no, I just changed my mind. Told the detective he strangled her, was violent. Told her that the SART nurse, excuse me, that there was no violence. So I had to had to take advantage of these inconsistencies in this case because they were critical to destroying the witnesses, the alleged victim's credibility. So this is actual cross-examination of the SART nurse going over what was most important.
Isn't it true that your examination consisted of you physically examining her with both your hands, right?
Correct.
And both your eyes?
Correct.
Okay. You were specifically looking for any kind of wounds, right?
Yes.
Injuries, right?
Right.
Damages, right? Okay. Isn't it true that that there were absolutely no injuries on her exterior that you found?
Correct.
Okay. Let's talk about that vaginal tear for a minute, okay?
Okay.
This was a very small tear as opposed to a large laceration, correct? Okay. This small tear could very well have been the result of consensual sex without enough lubricant, correct?
Correct.
Okay. Even this tear is not necessarily an indication that a sexual battery occurred, correct?
Correct.
Now, had there been a large laceration or large lacerations present in her vaginal area, then that would not have been within normal limits, correct?
Correct.
Okay, and that's not the case here. Everything you saw within normal limits, right? Okay. For the benefit of the jury, the bottom line here is that consensual intercourse without sufficient lubrication can cause a small 1 centimeter tear in a woman's vagina, correct?
Correct.
Okay. There's absolutely no bleeding whatsoever in her vaginal area, correct?
Correct.
And so what I like to try to do is funnel information. You start out wide like this and bring it down. So I question her and then I let her give a summary of what those bullet points were. And I set that up in the deposition so that I could then finish it in front of the jury while I was questioning her. And that was another part of the deposition that helped win this particular case. So impeachment of alleged victim with Facebook entry between her and the client. So I had to bring in a Facebook entry that came, conversation that they had during Facebook came up in the discovery. Alleged victim.
Ladies and gentlemen, we're going to continue with questioning the conversation from the Facebook that you just heard read to you. That transcript was provided by the defense in this case to the State's Attorney's Office. Mr. Barlow, you may proceed.
Thank you, Your Honor. Going back to the first page with y'all's conversation, I'm going to go back to the entry of June 20th, 1:57 a.m. And is that your response that says, okay, cool, I'll be back in 6 days?
Yes, sir.
And you're commenting on rendezvousing or meeting back in Jacksonville, right? That y'all will get back, and you're letting him know when you'll get back. He's letting you know when he'll get back from out of town, correct?
Yes, sir.
All right. And that entry right there, under that, where it says June 20th at 2 a.m., then I want a souvenir, laugh out loud, or LOL, I'll meet you there, NAKE ... What did you understand that word to mean? Naked. When you read that on your Facebook account, did you have the impression that he wanted to have reconvene his sexual activity with you?
Yes, sir.
Okay. What was your response?
All right, I'll pick you up something in Texas.
Did you say, no, I don't want to have sex with you anymore?
No.
Did you ever communicate to him after you received that you wanted to discontinue your sexual or not restart it? You said, all right, meaning, okay, I'm okay with that, right?
No, that's directly towards the city here.
Okay. So let me ask you a question. You just ignored that statement? Is that what you're telling us?
Yes, sir.
Why?
I didn't mean
But if it happened, it happened, and if it didn't, it didn't. You were just kind of either way. Is that right?
that. Sir, yes, sir.
Ma'am?
Yes, sir.
Okay. Thank you.
So audio highlights of alleged victims' bias, prevarications, and inconsistent statements. And so she wanted to marry him. That was a very important point because she was just a piece. He was just a little playboy, and I admitted that to the jury. And that was one of the problems. She knew he was going to be a pro football player one day. He was an excellent football player. He had 2 scholarships to different colleges, and she was trying to get her hooks in him early. But she was just a piece of meat, and she knew that. But she was willing to invest her body to change his mind, and it didn't work. And when it didn't work, he was poison to her.
You knew that your mother didn't like him, right?
Yes, sir.
And without saying why, you knew why she didn't like him as well, correct? Okay. And you yourself knew that he was not ready to settle down with anybody and get married, correct? You didn't want to get married? Isn't it true that you loved him back then in 2009 and even in 2010? Were in love with him? Isn't that true? Isn't it true that you wanted to have a one-on-one monogamous, faithful relationship with him? Isn't that true? Isn't it true also that you looked at him as a person that you could potentially marry one day? Isn't that true? Exactly. So the answer to my question is that you considered him a person that could one day be your husband. Yes or no?
Yes.
Okay, thank you. But you all were never boyfriend, girlfriend, correct?
Right.
You all never went to like dinner and movies and stuff like that, correct? Y'all pretty much just had a basic sexual intercourse relationship, correct? So if anybody asks you, his boyfriend, you'd have said no, correct? Because he wasn't, ever, correct? All right.
Now, so what I'm doing here is I'm destroying this allegation that they were in a dating relationship. That's why those questions were asked. And then, as you'll see in closing argument, I'm going to come back and hammer that.
I told you he didn't. Isn't it true that he told you he didn't want to just settle down with one girl? Didn't he tell you that?
No, he always just said that he wanted to focus more on football.
Than girls, right? But you knew a lot of girls liked him, didn't you?
Yes, sir.
You knew that before you ever had sex with him the first time, didn't you?
Yes, sir.
But you had sex with him anyway, correct?
Yes, sir.
Now, isn't it true that you were hoping that he would like you enough that that would be sufficient for him and he would be able to just leave these other girls alone? Isn't that true? And so that was a risk, a calculated risk that you were taking, right? And you made an investment of your body to try to bring that into fruition or to bring that into being. Isn't that correct? But that was a gamble that didn't pay off, did it? Okay. But had it paid off and he asked you to marry him, would you have tried to get permission from your mother to marry him? Because you wouldn't have needed it. You were over the age of 18, right?
I mean, I lost my virginity at 17.
Okay. Would you, if he wanted to marry you one day, would that have been something that you would have at least thought about? Okay.
Okay, so the reason, this is important is because I have to show that she was a scorned young woman, and I bring all that out in a closing argument. However, the reason she answered every question yes is because that was set up in the deposition. She couldn't say no. I had already locked her into this in the deposition.
Okay, I'm going to start at the bottom of page 43 and just read, starting at line 21 on page 44. Question, so you wanted a break? Answer, yes, sir. And then he wasn't stopping, and I started getting mad. And so finally I took my right hand and put it in the middle of his chest and pushed him maybe a foot off of me. I pushed him off about that far, a foot and a half indicating. And so I either said, seriously, you need to stop, or I said, you need to stop now. But I told him to stop, and that's when, at that time, both of our heads were at the headboard, and so then he moved me to where my head was at the foot of the bed, and my head and my shoulders started sliding out the bed, and I just assumed that I would just keep sliding and then fall off, and then he would stop, and he would just get mad or something. But he grabbed, I don't know what part of my legs he grabbed, but he grabbed my legs and pulled me back up on the bed, and he started choking me. Question, when he grabbed your legs and pulled you, when you say he grabbed your legs and pulled you back on the bed, I guess you all weren't having sex at that point. Answer, yes, sir. Question, you were not having sex, correct, at that point? Answer, right. Question, okay, so he stopped, is that right? Yes. Isn't that what you testified to at the deposition? Okay, thank you. So, going back to the question I asked you before we just went through this process, at the time that you claimed that you were sliding off the bed and you all got back on the bed, you were not having sex with him at that point, correct? Okay. And so the reality of what your allegations are is after that, he raped you. Is that what you're saying? So after that, did you ever tell the detectives what you just testified to today, that you all stopped having sex when you were sliding off the bed, he put you back on the bed, and then reinserted his penis into your vagina? Did you ever tell the detectives that?
Your Honor, this is improper impeachment, and we continue to sign the sidebar.
The judge overruled her objection. That was not improper impeachment. That was some substantive impeachment because, and let me just say this right here for practitioners, I went a little bit too far with that last question. I should have stopped it because it generated, when I said, so what you're saying right now is after that he raped you. See, he was never charged with that. He was charged with not stopping after she consented and then told him to stop. He was never charged as she just articulated. She made up that on the stand, and I was trying to figure out how to deal with it on the stand. And that little exchange right there almost cost us this case because of these questions right here. How many minutes went from when he pulled her up by her legs? No, he didn't. That was an allegation. And reinserted to the time he finished. See, that right there didn't happen. So I'm in trouble. We're in trouble right now. Also, and I know I'm in trouble because I hear the question, the judge is reading it, and I'm like, oh, Lord, I might have just lost this case. Also, did she testify on the stand whether she specifically said stop during that time period after he came out? So see, had I not gone on with that further part and said, so what you're saying right now, because I like to sum things up, and so I almost summed up or lost in that. I should have just left that alone. That was a critical error that fortunately we were able to overcome by the grace of God. But that almost, if we had lost this case, that's what I would have pointed to. I went a little bit too far with that witness, but fortunately we were able to recover. So here's some description of the impeachment in the closing argument that I did on the witness stand with one of the witnesses, the victim.
But that's the gist of it. And what happened was, when she's on her way back, they're communicating electronically, as the evidence shows. I'm just going to review it. And you've been taking excellent notes, so don't just rely on me. I'm trying to sum it all up. She's coming back to from Washington to Florida. She's coming through Texas. And they're communicating with each other electronically, and they are setting up a rendezvous to start back having sex. She left in June of 2009. She's on her way back in August of 2009. She's on her way back, in June of 2010. They're communicating with each other, which they shouldn't be. And they're setting up a rendezvous for sex.
Now, she was playing around on the witness stand when I asked her that until I had to impeach her on it by her Facebook statement. Oh, no, it would have been all right. And see, what you have to realize is every time she was getting ready to get into a box, she tried to wiggle her way out of it. Naturally stretching the truth, not understanding the gravity of what she's doing with respect to his life. But see, when you want something so bad yourself, and she confirmed you, my heart was hurt. Let's just stop right there. You know, when we get hurt emotionally, no more about that again. When we get hurt emotionally, we can overreact in ways that we sometimes come back and say, wow, did I really do that? Yes, you did. In rage, in jealousy, in anger, in bitterness, and resentment, and yes, ma'am, and so rejection. You know, when, just as a metaphor, when Saddam Hussein invaded Kuwait, and we went to extract it, he wanted their oil and their riches and everything else. That's what he wanted. And when he realized ultimately that he wasn't going to be able to keep the country that he invaded, what did he do? He scorched the earth. He set every well that they could on fire, burning the earth. Because, in other words, if I can't have this oil, if I can't have this wealth, you're not going to have it either. United States of America, England, and Austria, and everybody else. It was a scorched earth policy. That's what we have. We have a scorched, if I can't have dairy in our kitchen, nobody's going to have it. Scorched earth policy. And that's nothing compared to the age-old saying, hell has no fury like a woman scorned. And that's what we're dealing with, a young woman scorned.
So strategic attack on the battery by strangulation. I'm going to articulate to the jury the significance of the fact that they were not dating. Now, legally, they did prove that element, but I just kind of was able to outmaneuver them with my argument and my cross-examination. But legally, they proved that charge. I just had to convince the jury that they didn't.
A crescendo was building up to this case. This case should surprise nobody who really knows the history of these individuals. This was building up for a long time. She gets mad at him when now he's telling her, look, I got a lot of friends or whatever, and they're just having sex. They're not boyfriend and girlfriend. There's no dating relationship here. They don't go out on dates. She's only coming to his house late at night. When she comes in town from Washington, being away a year, she calls him at 12:40 something in the morning. And she usually goes to his house at night or at his house when his parents are away. That's not a relationship. On the street, forgive this phrase, but they call it a booty call. That's all that is. That's not a sexual, that's not a dating type relationship, romantic type relationship where you respect somebody and open the door for them and make sacrifices for them and ultimately want to marry them. That's not what we have here. We have a casual relationship that in the 60s or 50s people just be walking down the street holding hands and getting a soda or something. No, not in 2010. But it's not a dating type relationship at all.
It actually was. It was a dating type relationship based upon sex, but I just was able to fortunately outmaneuver the state on that point. Now, I'm getting ready to sum up the case based upon that deposition, and we'll get to that in a minute.
With his life. So, that brings us to Detective Dowling Thomas. Detective B.W. Thomas. That's Detective Believe Witness Thomas, but Detective Dowling Thomas when it comes down to Darien Kitchen. A detective, now listen, he's been on the force 19 years as a police officer. He just made detective this year. There's a reason for that. I don't know what it is, but there's a reason for that. You're on the force 19 years, you just made detective. There's a reason for that. I don't know what it is, but he confirmed that he just made detective. Also confirmed in his deposition that he was in the Berkeley for 3 weeks and didn't like that, so he left Berkeley. They might have kicked him out of Berkeley. Who knows? But he's in sex crimes. He's in sex crimes for 4 months. When he gets this case, he tells you that he has several different types of training. Number one, to write reports properly because it's very, very important. We know that. Very important to write reports properly. But he doesn't even get the date of the report right. He writes in his report, if my memory serves me correctly, your notes will be more accurate, that he got the call on the 5th of July about a situation that happened on the 6th of July. When in reality, she waited almost 48 hours after to call the police on Monday, the 5th, but then by the time the police gets the call, very simple stuff, dating that's, you know why that's important? Because they have to put the right date on the charging information. So they couldn't use his report. They had to use Officer Redgate's report, the one that came in today that they didn't call, that we had to call. Why did I call Officer Redgate? Because he's only been on the force, whatever he said on the stand, 3 years. But he got his report right, he got his date right. And he also put down accurate that she claimed, now this is the first police officer she talked to, she told him, according to Officer Redgate, that he choked me with his hands. And that's why every time we listened to that yesterday, sometimes she would actually say hands, and then other times she'd say hand. But I highlighted hand, because I knew what Officer Redgate was going to testify to. Very important witness. Why is he important, ladies and gentlemen? Because he was the first officer who came to the scene when she called a non-emergency number. Let's talk about that. Why was she?
See, so what I'm doing here, first of all, I'm doing a lot of substantive things. First thing I'm doing is, and I just want to let everybody know, I know that being a detective is a lateral move. That's not an elevation. But I also know that the average person on the street, we had no police officers in the jury, so those were lay people. I also knew that they didn't know that. So what I did was, by innuendo, I suggested that, hey, this guy hadn't been elevated to detective, and there must be a reason for it. I'm trying to give an innuendo that he's not smart. And unfortunately for him, he wasn't. And I proved it on numerous occasions. As a matter of fact, I'll just say this, ladies and gentlemen, I have never destroyed a witness so thoroughly in my career than this detective. And I did it with as much professionalism as grace as I could. He got destroyed so thoroughly that the state attorney attacked him in her rebuttal. And I have that on audio and video. I'm going to try to play the video. So if the video doesn't, that's the only video I got. If the video doesn't play, I'll revert to the audio. But I wanted you to see how she attacks her own witness after he suffered such destruction throughout the entire case. I had to destroy him and I had to destroy the young lady, but I had to do it with professionalism, tact, and class. And I was able to. It was very difficult to do that, but fortunately I was able to do it. So this is, in my opinion, the most important part of this whole case, the detective's deposition. I got him, I questioned him from 4:06 to 4:55 p.m., almost an hour. And I'm working it because I'm trying to get him to, like I said, I work in a funnel. So I start with things on a broad basis, and then I bring him down to a point. And I want to bring him down to the point where it's just her word against his. I was praying I could get him to say that. And when I got him to agree with me, that case was pretty much over. Now, I didn't know it at the time, but it was pretty much over when this deposition was taken on August 25th, 2010 at 4:06 to 4:55 p.m. And I'll show you why in a minute. Here's what I had on the PowerPoint in the courtroom. This is in closing argument. This is the last thing I'm going to say before I ask the jury to find my client not guilty.
The detective's conclusion. Deposition transcript of Detective Thomas taken August 25, 2010 at page 46, lines 15 through 19. Question asked by me. Okay, so the gist of this case, Detective Thomas, is what? What's the gist of this case we got here? Is it her word against his or his word against hers? What do we have? Answer. I believe it is. Now, if it were not that, you would have said, no, that's not it, because we have this evidence, we have that evidence, it's credible, it's undeniable, it's undisputable, and we have this on. No, But see, I had to go through almost an hour questioning him to get to that point. But ladies and gentlemen, that's just an hour of the state's key witness's own mouth. I believe. In other words, I have an abiding conviction in my heart that it's his word against hers. But they want to come into court and tell you that they've proven this case beyond the exclusion of a reasonable doubt when their main witness, first witness called to the stand, believes that it's his word against hers. And ladies and gentlemen, guess what? It's really not his word against hers. It's her word against the truth, because that's all he had. That's all he needed. That's a weapon that has never changed over time. It won't change now. I don't care how many times people try to make it seem A or B or C. It is what it was. It always will be what it has been. It always will be what it should be. The truth. The whole truth. Nothing but the truth.
Now, one of the things I was really doing, I was very aggressive yet professional. I would even call the young lady ma'am and stuff like that. I mean, I had to do what I had to do, but I didn't want it to seem like I was overreaching anybody. So here's the, if this video is not playing right, somebody let me know, and then I'll go to the next slide, which is an audio, but here's the video.
She's dealt with the consequences of Detective Burt Thomas, who didn't know the definition of inconsistent, meaning contradictory. She's dealt with the reality that just because you've reported a crime doesn't mean you're going to get the best detective, or even a detective who knows what he's doing, frankly. And should he be a sex crimes detective? Nope. Should he go right back to patrol so he can document better, so he can understand how to testify correctly? Yep. Are you going to hold that against her? Is that going to be consequences against her too? Let me be clear. This is not a situation where we have a detective who, because of their poor police work, has compromised the case. It's not a situation where we have evidence stripped from you because of mistakes. It's not like a robbery or a murder where the detective had the gun and didn't preserve it for prints. It's not like evidence wasn't taken, or it's not like a witness wasn't spoken to. We have Detective Thomas, who spoke to Audrey, to Ricky, and to Samantha, and to the defendant, and to his credit, didn't arrest the defendant right away, continued his investigation, and apparently he sees his role as more of an investigative role. I'm going to take everything down to the state attorney's office, and they'll decide, okay? But this whole new evidence and inconsistencies, do not fault her because he didn't understand the difference.
What was happening is I would ask the detective, I would show the detective, because the police did a control call where they had the alleged victim to call my client, and she was trying to get him to, you know how they work it, trying to get him to confess or admit something. And but there were, what the detective missed was that during that conversation, she was contradicting information that she had told the detective, the first officer at the scene, and the SARC nurse. But the detective was so focused on trying to get what he wanted, he was missing all those inconsistencies. So I highlighted every inconsistency, internal inconsistency with the alleged victim's own allegations. And I said, okay, when she was talking on the phone with my client, here's an inconsistency with what she told you. How did that impact your investigation? He kept saying it didn't. And I said, do you understand the difference between, you know, inconsistency? And he just couldn't. And so that's what she was trying to recover from, but it was too late. That's the audio. Okay, so here are the verdicts. Not guilty on everything. Say we all, not guilty on the sexual battery, not guilty on the domestic battery. And so that's life plus 5 years gone. Now, let me tell you what this lady did. The next week, she added a burglary charge to his other count. Added a burglary count that he was never arrested for, a burglary count that the burglary department division went out and investigated, because the alleged victim who wanted to have sex with all this business. Anyway, she claimed he broke in and raped her. No, he was her roommate's boyfriend who had been telling her how good he was, and she wanted her opportunity to have it with him. And she got it one night when her roommate sent her beau, which is my client, to the apartment to wait on her, and he had a key, and she wanted a quickie from him. But she told him, and he gave it to her, unfortunately. And then she told the police he broke in and raped her. And they sent the burglary unit out, and they said, no, 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 something suspicious here. We're not going to arrest him for burglary. But after she loses these verdicts, she charges him with burglary. 6-7 months after the charges, initial charges were filed. So we go to trial on that case. So he's facing life plus 15 years on that case. And we got a not guilty on the life charge, but he was unfortunately found guilty on the sexual battery charge. And the judge, being, 18 months on the bench, deferred to her and gave him 15 years, the maximum. So he wound up getting 15 years in prison. However, fortunately, we were able to use the equity and sentencing analysis system to get his the balance of his sentence reduced to probation. So the jury went out at 3:32 p.m., came back at 9:16. I believe it took them so long because I made that mistake. If I hadn't made that mistake, I think that jury would have come out within an hour, hour and a half, 2 hours, something like that. But I made a critical mistake, and I believe that's what happened. Somebody really wanted to convict my client, and somebody had to talk that person out of it. And let me tell you what I do when I pick a jury. I try to set it up such that I'll ask them, if you have an opinion that is different than everybody else's, 5 other people is completely different. Will you fight for your position? They'll say, yeah. I say, well, how long will you fight? Will you fight for 5 minutes? Yeah. Will you fight for 20 minutes? Yeah. Will you fight for an hour? Yeah. Will you fight for 2 hours? Yeah. If you really are convicted, will you fight? How long will you fight? I'll fight until I need to, as long I'm trying to get them to hang a jury if they can't convince the others to go along with their position. So fortunately, I did that kind of questioning, and I believe somebody was able to convince that person that my client was not guilty. So those are the verdicts. That's the judgment of not guilty of sexual battery and domestic battery by strangulation on the 7th of October, 2010. Okay, I have more about this case and a lot of others that I've won. In this book. It's available on Amazon. I have actual pleadings from this case in this book. So if you want to check it out, you can get more information on this case through this book called Guilty Until Proven Innocent. And it gets into some of the things that we're getting ready to see with the law that's coming up. Unfortunately, the law is being challenged. And so I saw that coming when I wrote this book back in 2016. So it gets into a plea of not guilty, reasonable doubt, the defendant's right to a fair trial, equitable sentencing, and what the judicial system is supposed to do. I saw this coming, what's getting ready to happen in America right now. The courts are being challenged. I deal with that in that book. I saw it coming in 2016. So I address it in this book along with cases. One of the most difficult cases I had was a public defender, and I had a guy who had soiled his clothes and all that business, and they arrested him for DUI. And he, but when the police got there, he passed all the tests, and a witness confirmed it, and we were able to win that case, but it was very difficult to win. So what if you lose that trial, and or your client is facing a lot of times? What happens? What do you do? The goal is to fight just as hard, if not even harder, for an equitable and properly proportional of your client's case. Most people don't know this, but there's an ABA standard on you should know what the judge's sentencing practices are before you either advise the client to go to trial and or enter an open plea to the court. That's an ABA standard on that. But how do you get that information? That's what we're going to talk about. How can you discover the sentencing trends for the charges for which your client was found guilty? Well, we have the equity and sentencing analysis system. It's inquiry, reporting, and statistical analysis software, web-based software that can analyze, compare, and contrast sentencing data as follows: statutory charges, score sheet points, offense date, sentence type, sentence date, sentencing judge, minimum and maximum sentencing range, defendant's name, race, gender, date of birth, defendant's age at sentencing, case or docket number, so you can do your own research. ESAS reformats existing criminal history data to craft equitable sentences by comparing and contrasting prior sentencings of similarly situated persons. This exercise is performed at a mouse click, which with results in a few seconds, depending upon your internet speed. So here are the services. You can get a subscription where you run the data yourself for 12 months, unlimited searches. You can get 3 circuits at this price right here. Minimum is 3 circuits. And we're fully endorsed by the Florida Bar. You'll see that in a minute. So get a 10% discount from the Florida Bar. And in this scenario, you're paying for this service almost just like you do LexisNexis, Westlaw, or Fast Case if you have their super edition. Or you can get all 20 circuits, and that's the price for that, less your facto discount and your Florida Bar discount. Facto members get a 15% discount. That's an extra 5%. And by the way, if you want to know, state attorneys, I offered them the same thing, but they never gave me an audience, never gave me an opportunity at the organization, the statewide prosecutors organization. However, we did convince one state attorney office to get ESAS, and they used it for about 2 years. So prosecutors can use it if they want to as well. Custom searches, we run the searches for you, and we provide spreadsheet data, and that's the cost less your 10% Florida Bar discount or your 15% Florida Association of Criminal Defense Lawyers discount. That is the statewide organization. However, we do have a local organization that is requesting pricing for their entire facto membership to get a subscription. And we do have custom prices for large groups like public defenders, RCC attorneys, and state attorney offices, whereby sometimes it's less than $10 per month per attorney, because we have a graduated step discount process where you get a lot of, the more people you have, the greater the discount that you have. So if you're interested in a large group or PD's office or something like that, just reach out to me. You have my email in a minute or so. Here's where officially endorsed by the Florida Bar, 10% discount, facto 15% discount. And I also do expert witness testimony. So not only can we provide the data or let you get the data, I can also come in and do an expert witness report. We put all that data in a narrative report. As you know, a lot of people aren't, digitally inclined, especially a lot of judges. And so what I do is I put it in a narrative form. We put charts and graphs in that report, so it's easy to read the narrative, then see the digitized information. We just had a great success last week. I testified down in the 12th Circuit. The young man had 40 counts of possession of child porn. He was facing a minimum of 44 years in prison to a maximum of life. The state attorney offered him the bottom of the guidelines, so the attorney convinced his client to enter an open plea after he showed the client, the data that I provided. And then the client hired me, his mother hired me to do an expert witness report. And so they hired a clinical psychologist as well as myself as an expert. And both of us testified last week. And the judge sentenced that young man to 3 years, mitigated downward departure, 3 years, followed by 10 years probation with special conditions that he undergo, psychosexual counseling and things like that. He was an autistic person, by the way, in his 40s, I think, but had the mindset of about a 12, 13, or 14-year-old. And so that case worked out well. If you want to see some more results, go to technologiesforjustice.com. You can look at some more of the results. Expert witness reports run $12.50. Expert testimony remote, that is by Zoom or Microsoft Teams, is $1,500 flat. However, if you want me to come in personally, that's a custom price, and that's going to depend on how far I have to go, what transportation there is, per diem, hotel fees, and things like that. But it's not that bad. I mean, your client is paying for it anyway. So expert testimony is not subject to Florida Bar or facto discounts. I'm also have a contract with the JAC, Justice Administrative Commission. So I'm authorized to testify in all 67 counties, all 20 circuits. So if you get a motion for cost, which some lawyers do, and then they hire me to do the report and the data and all of that and have the state to pay for it. So you can have a motion filed to receive costs, and if this gets granted, I can go through JAC. Also, with respect to public defender's offices, I do expert witness testimony and things for them as well. But they have, a budget through JAC, as well as they have budgets through their counties. And so sometimes they'll use their county budget to hire me or the state budget. Okay, it's just about 1 o'clock, and you're going to see this survey after we get off. And please, ma'am, this is real brief. It is anonymous. You're familiar with these, so we won't know who's filling it out. Just be as brutally honest as you can. Just treat me like you want to be treated if the roles were reversed and you were doing this seminar. Amen. And so as far as, let me go back. As far as the CLE, you're going to send an email. That's my email address right there. You're going to send an email request saying, I've watched the video, or I've watched the live now, or if you watch the video later, I've watched the video of winning cases and depositions. Please send the CLE number. And I already have a boilerplate email. I'll just copy it, paste it, and send you the CLE information. Any questions that we have? It's 1 o'clock on the dot. Any questions before let me come out of this right here. Any questions from anybody? Thank you all again. And I hope that you got something out of it. Any questions right quick? Not in the chat, please, because it's hard for me to do the chat and control the system. Please articulate it. Yes.
Yes, I have a question. This is Gabby Radcliffe. Is it
Okay.
possible to pay on a case-by-case basis instead of having a subscription for the research?
Yes, that's what a custom search is. Yes, ma'am. Yes.
And-
We'll send you, we do electronic invoices. And so what some lawyers do is they collect it, put it in a trust account, then pay it. But other lawyers, once they get the fee and talk to the client, sometimes they'll have me to send the electronic invoice directly to the client. The client pays it, the lawyer doesn't deal with it. And then once it's paid, I do the work and send it to the lawyer. So yes, ma'am, that's correct.
Thank you.
You're welcome. Anybody else? I don't want to keep you too long. It's 101.
How can we get the CLE case course number for
Okay.
credit?
All right, let me go back. Send an email to technologiesforjustice@gmail.com. That right there. Send an email to technologiesforjustice@gmail.com. Maybe I should put this in the chat too, just to be safe. But yeah, send me an email requesting the CLE, and I'll get it right back to you as quickly as I possibly can. Let me put this in the chat right quick. Any other questions while I'm doing this?
Thank you.
You're welcome. And if you all have any questions, you got some of these hard cases or whatever, I'm available. I want you to do well. Trust me. I've seen it all. And I've seen some people who have not been properly trained. I hate to say it. So I'm willing to help you. And I'm not going to charge you. Okay. Got any questions about a difficult case or something like that? Reach out to me by email. I do it all the time with young lawyers, older lawyers. And I serve the full gamut. I want you to do well. And sometimes some of these mistakes, like you saw the one that I made, it could cost your client. We have strategies that can avoid 3.850s and things like that, especially with respect to the data. Put this in the chat. Anybody else? Well, as soon as I finish putting this in the chat, I'm going to get off. Yeah, I think I got it here. Oh, no, I don't. At Gmail.
I think I put it in there for you,
Thank you.
if I got it right.
Thanks, Al. Appreciate it.
Thank you all. Y'all have a very blessed day.
You too, my friend.
All right. Okay, bye-bye.
It
Thank
was
you.
great. Thank
Yeah, it
you.
was great.
Thank you. You're welcome. Yeah, I
Very
think I-
good seminar. I appreciate your efforts. Thank you.
Thank you, sir. I was trying my best. Put a lot of work. I wanted you all to get a lot out of it. Hopefully, you did. All right. All hearts and minds are clear. Y'all have a very blessed, peaceful, and prosperous day. And like I said, if you need anything, just let me know. All right. Be blessed.
Be well.
Okay.